Thursday, June 7th, 2023 afternoon session of the Portland City Council. Hello again. Keelan, please call the roll.
Good afternoon. Ryan.
Here.
Gonzalez.
Here.
Maps. Rubio.
Here.
Wheeler.
Here. And now we'll hear from legal counsel on the rules of order and decorum. Good afternoon. Thanks for being here.
Good afternoon, Mayor. Welcome to the Portland City Council. To testify before council in person or virtually, you must sign up in advance on the council agenda at www.portland.gov/council/agenda. Information on engaging with City Council can be found on the council clerk's webpage. The presiding officer preserves order and decorum during City Council meetings. The presiding officer determines the length of testimony. Individuals generally have 3 minutes to testify unless otherwise stated. A timer will indicate when your time is done. Disruptive conduct, such as shouting, refusing to conclude your testimony when your time is up, or interrupting others' testimony or council deliberations will not be allowed. If you cause a disruption, a warning will be given. Further disruption will result in ejection from the meeting. Anyone who fails to leave once ejected is subject to arrest for trespass. Additionally, council may take a short recess and reconvene virtually. Your testimony today should address the matter being considered. When testifying, state your name for the record. Your address is not necessary. Disclose if you are a lobbyist. If you are representing an organization, please identify it. For testifiers joining virtually, please unmute yourself once the council clerk calls your name. Thank you.
Thank you very much. First up is item 471. This is a first reading of a non-emergency ordinance.
Add utility operators code to govern utility access and use of the city right-of-way and adopt fee schedule for utilities operating in the city right-of-way.
Colleagues, this item is sponsored by Commissioner Rubio. But before I hand it over to the Commissioner, I want to say that this code helps the city achieve efficient outcomes for both the city as well as for our utility partners. This project has been underway for some time. It started when the former Office of Community Technology was in my portfolio under the leadership of Elizabeth Perez. Since then, the franchise utility program has moved to the Bureau of Planning and Sustainability, which is in Commissioner Rubio's portfolio. I want to thank Elizabeth and her team for their diligent work. Elizabeth has passed the baton to the Bureau of Planning and Sustainability, and their team is now doing the important work within the Community Safety Division. This code is an important step for our city to consolidate work and processes to create efficiencies and recover fair and just compensation for use of the public right-of-way from our partners who operate and use assets within that right-of-way. I'll now turn it over to Commissioner Rubio to introduce the ordinance.
Thank you, Mayor. Before I introduce the item, I want to make one amendment to the ordinance and 2 amendments to Exhibit A, which is the proposed city code language. And the ordinance amendment includes a new finding, which reads number 9. The City Council adopted resolution number 37168 on November 12, 2015, which opposes the transportation and storage of fossil fuels in or through Portland or adjacent waterways. The resolution states that prior to any further council action related to code changes to advance the policies in the resolution, the mayor will schedule a work session to review proposed code changes and an executive session to review the legal considerations of any proposed code changes. Although it does not appear that this directive relates to the ordinance, the purpose of which is to codify existing utility franchise agreements, out of an abundance of caution, because our utilities, such as Northwest Natural, PGE, and Pacific Corp, will be subject to this code. And these are the requirements that have been met as follows. First, the first reading of the ordinance fulfills the work session requirements, and the city attorney has met with each of the commissioners to discuss the legal considerations of the proposed code changes, so no executive session is necessary. As such, I motion to amend the ordinance to add Directive 9. May I have a second?
I'll second.
Thank you. The code amendments I am recommending are as follows. First, on page 5, bullet R, the proposal is to strike language starting on line 1 after the word "sell" through the remaining sentence and sub-bullets 1 and 2 and replace with section 12.15.030 definitions. R, small wireless facility or small cells means a small wireless facility as defined by the Federal Communications Commission in 47 CFR, Section 1.6002I, and may be amended or superseded. I motion to amend Exhibit A to revise the definition of small wireless facility or small cell. May I have a second?
I'll second that one as well.
Thank you.
Can I ask just a point of clarification for the record?
Sure.
This second section, or this second amendment, is codifying our definition of small cell to be in alignment with the federal definition. Is that accurate?
No, I'm going to ask staff to answer that first. Andrew?
And please introduce yourselves for the record.
Good afternoon. My name's Andrew Spear, and I'm the Franchise Utility Program Manager for the Bureau. Could you repeat your question, Mayor?
My understanding of this is it's bringing us into alignment with the definition of a small wireless facility as defined by federal code under the FCC. Is that accurate?
Yes.
Thank you. That was my question. Glad you got the exercise, though.
Thank you.
Okay, Second Amendment is a new subsection to Section 12.15.090, Utility-Specific Provisions. A, wireless services is amended to add a new paragraph 8 to page 18 and read as follows. Section 12.15.090A, notwithstanding Section 12.15.140, the fees set forth in Section 12.15.140 will be paid annually for each year during the term of the license. I motion to amend Exhibit A to add a subsection to utility-specific provisions. May I have a second?
I will second.
Thank you, Mayor. The ordinance before us today adds a new chapter to our city codes that will allow city staff the ability to more efficiently administer utility access to the right-of-way, or ROW. The code includes regulatory provisions that treat all users of the ROW in a fair and transparent manner and responds to the full range of the different types of utilities, from pipelines to telecommunications. This effort has been a multi-year process that has included significant outreach with partners and changes to the draft code to address policy and operational concerns raised by the industries and companies governed under this code. Our outreach work has started internally, as some of our own bureaus are subject to this policy. And for several months, we worked with those bureaus directly, and with Commissioner Mapp's office in particular, as he had concerns related to the Water Bureau and the Bureau of Environmental Services specifically, and we incorporated that feedback. I want to stress some key points with you on the implementations of the code. The goal of this effort is good governance, a better and more fair way of doing business with our ROW users. Because this exercise was not about increasing city revenues, a commitment that I made up front, that this code is not making changes to the fees or fee structures for what is in place currently. Companies that have current franchise agreements will continue to operate under their franchise agreements until the expiration date. Only after expiration will they be subject to the new ROW code. If a company wants to be subject to the new ROW code sooner, they can make that decision. This code mimics closely the same language and provisions that exist in current franchise agreements. And lastly, for licensees who pay on 5% of gross revenues currently, the calculation of gross revenues under the ROW code remains very similar as today. The administrative rules included in Exhibit C of this ordinance simply clarify what is included and not included in the calculation for gross revenues, because there has been confusion in the past. Bureau staff have worked with parties to make edits to address policy issues raised and give additional clarity in both the code and administrative rules. And I want to share publicly that after this code is adopted, BPS will happily engage industry stakeholders along with all council offices to look at costs associated with the right-of-way. I will now pass off to Director Oliveira and Andrew Spear to present the ordinance in more detail.
Welcome.
All right. Thank you, Commissioner, Mayor, Commissioner Gonzalez, Commissioner Ryan. Good afternoon. Donnie Oliveira for the record, Director of the Bureau of Planning and Sustainability. As introduced, this ordinance increases administrative efficacies for both the city and our utility partners to improve invoicing, payments.
Wait a minute.
Oh.
Is closed captioning working?
We're troubleshooting. We may need a short recess to reset.
All right, why don't we take let's take a 5-minute recess and let the closed captioning, and then you can start over.
Mayor, I think we're ready.
It works? Perfect. Good.
Recording in progress.
All right. We're out of recess. And why don't you guys go ahead and just start over?
Thank you, Commissioner, Mayor, Commissioners. Don Yalavera, Director for the Bureau of Planning and Sustainability. So as introduced, this ordinance increases administrative efficacies for both the city and our utility partners to improve invoicing, payments, consistent audit practices, and code requirements that apply uniformly to all utilities. The right-of-way is the city's largest physical asset that we manage on behalf of all Portlanders. It is an essential public good. The proposed code before you governs the legal access to the right-of-way for utility companies who own and use assets in the right-of-way. While this code adopts the current fees that compensate the city and Portlanders for the use of the right-of-way, the proposed ordinance does not change the existing fees we've been charging for the past several years. I want to acknowledge that we've heard concerns about potential FCC rules violations due to our fees for small wireless facilities, but our city attorneys have consistently affirmed that our cost-based structure is well within the city's authority to charge. In addition, what is not included in this code is the management and day-to-day operation, design, and engineering standards for the right-of-way, which is conducted by the Bureau of Transportation. Essentially, this ordinance speaks to legal access, not the management, design, or cost of the right-of-way. The code gives the city a uniform document that governs the legal requirements for utility use of the right-of-way. It is the priority of myself and my staff to ensure the code protects the right-of-way as an asset while ensuring the efficient administration of the code with our utility partners. As Commissioner Rubio stated, my team and I remain steadfast in our commitment to ongoing analysis and improvements with our partners on the components of the right-of-way that are outside of this code. I want to be really explicit. A no action on this code is status quo. Nothing changes regarding fees or revenues for the city. I will now pass it to our franchise utility manager, Andrew Spear, who will walk us through the code, specific provisions, and the incredible amount of stakeholder engagement and process we as a bureau and our predecessor at the Community of Technology Office have had to produce the ordinance before you today. Since coming on board in mid-March with the city, Andrew has had significant and direct engagement with parties and made several key edits to the code and administrative rules that address the key policy concerns raised by our utility industry partners. Thank you. Andrew.
Good afternoon. My name is Andrew Spear, and I'm the Franchise Utility Program Manager at the Bureau of Planning and Sustainability. Thank you, Commissioner Rubio and City Council. I want to walk through the basic purpose of the ordinance and the code to give some context and background. Administratively, this creates efficiencies across both the city and the affected utilities, consistent treatment of utilities who operate in the right-of-way, fair compensation for private use of a public asset. I want to point out that the last point around fair compensation is an important one when we think of the right-of-way and it as an asset held in trust by the city for Portlanders. As city officials, we need to ensure that we recover fair and just compensation so that we avoid subsidizing companies who are making profits due to their use of the right-of-way. Next, I will present a presentation to you and give some details behind our process and where we landed today with the code before you. This first slide provides a background of the value of the asset that the city maintains on behalf of Portlanders. You'll notice that the percentage of land mass within the city is roughly 20%. Most of that is made up of roadways and sidewalks. The value of that asset is estimated to be $13 billion, and essential services could only be provided except through use of the right-of-way. The city manages the utility access of the right-of-way through franchise agreements currently. Franchise agreements are individual agreements between the city and an individual company or utility providing service where an asset needs to be installed in order to serve customers in Portland. Traditionally, we have had passive management with a large number of franchisees and license holders within the city. The revenue, I would like to point out, is that's the amount collected annually A large portion of that revenue is calculated on a percentage of gross revenue, with other fee payers such as per-foot customers and the wireless providers on a per-site fee. I'd like to just provide some context on what this code is and what it is not. This code is not setting new fees or fee levels. It is not an assessment of fees for work in the right-of-way, i.e. building permits, permitting to access underground facilities. It's not the financial compensation for maintenance and operations of the right-of-way, and it is not a path to create advantages for a single utility. Much of the language of the code is commensurate with our current franchise agreements within the city and utilities. Next, I just want to provide some context on the right-of-way code in general. That first sentence there is how I like to think about the right-of-way code or franchise agreements in relation to their operation with city partners and utilities. It's the legal access, or it grants and gives authority the legal access of companies to operate in the right-of-way and install their assets. The purpose of this code is to reduce administrative burden, create a level playing field for utilities and customers alike, and ensure fair compensation of those uses. Next, this slide is just to provide some background and overview of what cities in Oregon have done and adopted like codes. You'll notice the list is quite long, and even more cities across the region are adopting like right-of-way codes to avoid franchise agreements. Franchise agreements traditionally are multi-year processes that require a lot of legal engagement and costs that have not been paid for by those instituting the incremental costs upon the city, i.e. the requesting company or utility of the franchise agreement has not paid or compensated the city for the legal services the city has provided in those negotiations. So I think it's an important point as we think about ensuring fair compensation during the process of negotiating franchise agreements. In terms of stakeholder engagement, this has been a 2+ year process. As the mayor pointed out, started with Director Perez as part of the Office of Community Technology. There's been 2 formal rounds of public stakeholder comments held where staff reviewed comments, provided feedback, and adopted some changes. Since my coming on in March, we have had multiple rounds of stakeholder engagements with the core utilities, PGE, Pacific Power, and Northwest Natural. We have adopted changes given their feedback, namely in the areas of the definition of gross revenues. We've also had direct conversation and engagements with the wireless providers, AT&T, T-Mobile, Verizon, and then Crown Castle as a provider of services for the leasing of assets that the providers use and have leases for. We've made movement on key policy issues, given stakeholder feedback. And next, I'll provide some context on what those concessions have been. One of the big sticking points for the core utilities, PGE, Pacific Power, and Northwest Natural, has been the definition of gross revenues. The definition of gross revenues is identified within Exhibit A in the code, and then within the code, it delegates authority to the director, the bureau director, to then institute administrative rules for the definition, for further defining gross revenue calculation. We have before you an Exhibit C draft of that administrative code that includes the definition of what is included and excluded in gross revenues. We've made a large movement in policy with excluding the revenue associated with the recovery of franchise fees. The utilities on our bills provide a line item that collects the revenue that's due to the city for the franchise fee, i.e. the percentage of gross revenue. That money, under the previous iterations of the administrative rules, was included as part of gross revenues, so we are now saying that that is excluded. It is the tax on a tax argument. So we remove that from the definition of gross revenues to add clarity and conduct the calculation as it happens today with the providers. Wireless providers being subject to fees and not gross revenues. There was a concern by the wireless companies that the city was going down a path of charging gross revenues, 5% of gross revenues on their revenues earned by us as Portlanders. We made clear in their section of the code that that is not the intent, that they pay on fees, per site fees, which are the small cell and macro site fees that are in Exhibit B within the ordinance. Decommission assets. Northwest Natural was interested in a language change that provided the ability, if there was identified by the city and the utility for an asset to be safely decommissioned and remain in the ground, that it be able to remain in the ground until it needed to be moved, whether that's identified by the city or otherwise. So we made clear language there that that is an option and that the city would be able to work with the utility on that matter. Current franchise holders, as was mentioned by the commissioner and by Director Oliveira, there was language included within the code that clearly states that if you hold a current franchise in the city, that you will remain on that franchise agreement until the expiration of that franchise. So just codifying that at the end of the Exhibit A. The purpose of this slide, I wanted to identify possibly what you've been hearing from industry and help you understand what the rationale is for given arguments or items that have been presented before you in terms of lobbying. There's been some concern by industry and stakeholders that the 5-year utility license term is too short. There's also a provision within the city's charter that requires, if we are issuing a license as a city, we cannot extend that license beyond 12 months. And so that's a practical matter. So within the code, we have a renewing license for up to 5 years. So each year they're providing a new license application and we renew that. Also, when we think back to many utilities have asked, well, why just 5 years? And I think a good visual for you all to consider, when you think back to 2003, 20 years ago, when we were when cell phones were becoming more prevalent, and you think about the level of technology that existed then versus today, that generational change in cell phone technology, that would have been with traditionally franchise agreements had lasted 20, 25 years, and so the city would have been locked into the operating agreement between the company, the utility, and how their technology progressed for that 20-year period. This code allows us to adopt and implement new technology in a more responsive way that ensures recovery of incremental costs that utilities and providers impose upon the city in the right-of-way. Next, the cost study for small wireless attachment fees. I know that there's been direct comments and written and verbal comments given that the city is violating the FCC order by not having a just and reasonable cost that is based on facts. As Director Oliveira mentioned, we have gotten legal guidance and review that what we have calculated is within the code for the FCC order, which simply states that you are able to, cities, jurisdictions and cities are able to calculate just and reasonable costs provided that they are founded and within reason. And so the costs that I have calculated, the small cell fee, are just based on practical administrative and FTE costs for most of the costs being within my team and the 4 FTE that are within. Next is number 4, competitive advantage over those with existing franchise agreements. The basis of this code was taken from both other jurisdictions and their right-of-way code and current franchise agreements that we have with parties, namely the most recent franchise agreement being in 2018 and implemented in 2019 with AT&T. When you mirror the two sides of the code and that franchise agreement, many of the key components remain, the language remains the same, and so there's no intent to have different prices or fees associated with the right-of-way code or the current existing franchise agreements across the different industries and providers that have franchise agreements. And the definition of gross revenues being included in code, that was a policy decision that the Bureau at the time made with regards to having a living document that could be able to be amended easily and be able to be responsive to both industry and city needs. The decision was to include a administrative rule that would be governed by the director, and the code delegates that authority to the director. Just practically, there's already 2 sections that I would like to include as revisions for when the code is passed and we go out to industry and we issue our draft proposal. I'd like there to be a clarity on fee payers, how they're assessed, and what timing in which they pay, and then also an administrative section that discusses the administrative process around the licensing and application fee. And then lastly, I wanted to note the items that Commissioner Rubio raised as the amendments. Those were 2 key items. The definition of small cell facilities, the city's definition of small cell facilities was included in a more defined and narrow manner than that of the FCC definition. And so in order to create some better understanding with our industry partners, we've made that change to adopt the FCC's order, which is a bit more encompassing of the different types of facilities that are included or not included within the small cell structure. And then lastly was the item on the fee payers for wireless companies and those being annual payments. Currently, they do pay us annually for their site fees, and so this just codifies that within their section of the code, which is wireless companies. I wanted to just provide you lastly with an overview of what you are considering. So Exhibit A is the chapter itself, the chapter of the row code. It is a new chapter within the city's code and is Chapter 12. Exhibit B is the fee schedule associated with the code. It includes the gross revenue payers, so the 5% of gross revenue, the wireless fees, i.e. the small cell wireless and the macro sites, and then the per foot fees along with the nominal administrative fees. And that concludes the presentation. I would like to thank the commissioner for her support, and I'd like to thank my leadership via Director Oliveira, and their support has helped us achieve and adopt changes to the code that I believe give meets industry where their needs are at, and helps the city understand its risk profile and maintain that through time to ensure that no undue risk is imposed upon the city given the code. And that concludes the presentation, and I will turn it back to Director Oliveira.
Thank you, Andrew. Commissioners, I just want to acknowledge, last night we sent an email over to your offices that were outlining these amendments that Commissioner Rubio shared this afternoon. And then once we had legal counsel's final review, we shared those this morning with you all. So I apologize if those didn't hit your inbox as soon as we would have liked, but that those were conveyed. And again, we are fully committed to continuing the conversation, assuming this code is adopted, to working with industry to evaluate in a phase 2 format the fees and costs associated with the right-of-way, including our partners in the other bureaus.
Great. Could I ask a couple of questions?
Please.
And then I know we have some public testimony as well. So this is thick, and I want to make sure that I've got my hands around it. So to clarify what you had said in your presentation, what we're discussing today, this ordinance is specific to the program for managing access to the public right-of-way. So it is a narrowly defined ordinance. Is that correct?
Yes.
Okay. And my understanding, based on what you said, is, and we've seen a number of different charts, a number of different notes, a number of different spreadsheets. There was one spreadsheet that identifies the fiscal impact of this particular ordinance. This ordinance is referring to the $650-ish thousand that is going towards the specific management of the program as narrowly defined by this ordinance. Is that correct?
For small cell
For
facilities,
small cell
yes.
wireless, correct.
Yes.
And how many FTE are associated with that program?
There's my FTE of four to include myself, a portion of Director Oliveira and Deputy Director, BPS Deputy Director, some portion of legal time, and then a small amount of policy time that's related to a PBOT FTE.
Okay, and some of the testimony I received on this showed a chart identifying what the cost per pole basically for small wireless is, and it showed our cost being about $1,450 per pole. Is that correct based on this particular ordinance?
For that would be applying to the utility license and legal access
Yes.
portion, yes.
Yes. And I also saw some charts that showed some costs or fees associated with PBOT. Am I correct to say that that is not part of this ordinance?
Correct.
Okay. And then in addition to that, in addition to this $650,000 spread out over our 650,000 residents, there is a utility fee, a franchise fee that you said is about 5%. Is that accurate?
5% of gross revenues,
Okay,
yes.
and that does not change. This ordinance does not change that, the numbers behind that. Is that correct?
Correct.
Okay, and just out of curiosity, that 5%, where does the city of Portland come in? Are we high? Are we low? Are we in the center? Where are we on that? Just so I have some idea of that.
That is the kind of standard in which almost all cities operate within. Some are slightly above and have a privilege tax is generally referred to as.
Okay, so I'm still trying to figure out what the hubbub is about, because what I'm hearing is it's $650,000 to manage the right-of-way entry program for 4+ FTE spread out across all of those poles at $1,450 for the small cell wireless. And I saw in one of those spreadsheets, I don't think it's my place to name the providers, but it was about $300,000 per provider for the 2 large providers per year for that fee. Is that about right?
Yes.
So, and one of those providers, I did a quick Google search, has revenues of $130 billion. So we're talking $330,000 per year on gross revenues of $130 billion. Is that what we're talking about here?
Well, to clarify, it would be if gross revenues were assessed, it would be within the
Right, and
customers.
you had
but
a
yes.
different way of defining it, and I'll trust you in the industry got that right. I just did a quick Google search.
Sure.
And so I'm trying to just get some comparative idea of what we're talking about. But it looks like it's about $330,000 to help you with your 4+ FTE manage the right-of-way program.
Yes.
Correct.
Okay.
Mayor, if
Yeah,
one other
please.
addition, along with that, our costs stay flat. So as more small cells or wireless facilities are introduced, the actual cost per unit goes down because our costs stay
That
flat.
makes sense, sure.
So there's also a scenario where as the utilities are expanding, their costs go down per
Okay,
unit.
so you further said that there are no new fees or increases associated with this ordinance. Is that correct?
Yes.
There are other ways that cities would recover costs for this. One of the things I noticed as I did my research is it's a little bit hard to look at a chart and compare apples to apples from Portland to other cities, because other cities use very divergent means and diverse means of recovering these costs. For example, some cities have utility taxes, right? And where are we in that department? Are we high, are we low, are we in the middle?
In terms of within the context of this program is?
Yeah.
Yeah, well, with regards to the 5% of gross revenues, we are at the standard. Within the fees assessed to wireless, some choose the safe harbor rate of 270 per site, and some have cost studies that support other ranges above 270. Portland is on the higher end, but not the highest. And I think an important note there, Mayor, is that their industry has argued that, we should do an equivalency study and understand what other cities are at. And I want to point out the FCC order and what it states. It states a reasonable approximation of costs. Those costs themselves are reasonable, are non-discretionary, allowing localities to charge fees above the safe harbor rate level upon this showing recognizes local variance in costs. And so we have to use our own costs and structures, right, are the way we structure our bureau and the administering of this project and this scope of work is unique and distinct. And so to use an equivalency study or an equivalency of another jurisdiction would not be complying with the FCC order.
Okay, fine. But for the purposes of this ordinance and the city of Portland, you are saying that the legal requirement is that you may not charge more revenues to the providers than the cost of administering this program. Is that accurate?
Correct.
And you have been transparent about what the costs are associated with this program and the revenues collected to support it?
Yes.
I know I saw a spreadsheet. I assume that's publicly and widely available. Again, it was about $650,000 for 4 FT plus, I think some legal support or something else. So maybe it would help me during public testimony if people could tell me what the real concern is here, because I'll be honest, I'm not seeing it. It's a narrow ordinance. It's focused on access to the right-of-way. It mentions but does not include any changes to the existing franchise fee agreements, which you say are center of target-ish, certainly not out of the ballpark. It is legally permissible under FCC rules, and it acknowledges there may be other city bureaus that charge. If you are going to construct something on the public right-of-way, you're going to have to get a permit. And yes, the Bureau of Development Services will charge you for that. If you go across a right-of-way that is administered by PBOT, there may be some cost associated with the work in a PBOT right-of-way. So this is not the total cost. This is merely the front door. This is legal access to the right-of-ways that are owned by the people of this city.
Correct.
And for that, you are charging a grand total of $650,000 for the small cell service access. Is that right?
Correct.
Okay, good. So if I got this wrong, somebody needs to tell me, because that's what I'm reading, that's what I'm seeing in the proposed ordinance, and it would be helpful for me to understand if there's more to this. Commissioner Gonzalez.
I just had a follow-up question in this area. So one of the arguments we've been hearing from industry is that the city's current fees are out of market. That's the argument, that they're high, and that's leading to underinvestment in the Portland market. That has some digital equity implications if it's true. And so, and by that, let me be crystal clear, right? Closed schools 2020, we send Portland children home. They're dependent on what internet they have in their homes to have access to education. It's not a little thing. It went on for a year. Digital equity has been in vogue as a policy priority in the city of Portland for a number of years. It waxes and wanes. I happen to believe it's quite important, but it waxes and wanes in importance at City Hall. Do you have data on relative investment in the Portland market versus some of these other markets? And certainly we're going to hear from industry, I suspect, on this point, but I'm just trying to calibrate here, because the argument is that we're charging high, that's disincentivizing industry to invest in this market, and I'm just curious if you have ways to calibrate that to,
We don't have any direct data. I mean, that's proprietary to each company, and so we don't have direct data. I will note that when you look at your cell phone bills, they are charging jurisdictional taxes. So they are recovering those costs. So the argument that they are not installing and making capital investments, I've not been able to understand when they are able to recover the specific taxes and fees associated with each jurisdiction.
So I think this is actually a really important point, because that raises a separate question, right? We're at a time where we're really scrutinizing what's being passed through to consumers. If we are out of market for what we're charging, wireless carriers, and we're passing that on to Portland residents, it's an area that I at least want us to be sensitive to. So I think this is, Andrew, I take at face value what you just said. I just want to make clear, is this something that's largely being absorbed by the carriers, we think, or is it largely being passed on to consumers? Because there are concerns either way. There are pluses and minuses either way. I feel like on this topic, I've been somewhat unclear. I had assumed it was being passed on to consumers, but if it's just for the initial access, right? Is that what we're talking about, or is it go ahead.
So my background is in utility rate making. I'm an economist, and I've worked at PG and Northwest Natural doing regulatory price setting and rate making. Under that construct, that is transparent rate making and pricing at the PUC. The wireless carriers are not subject to regulatory price setting, and so I can't answer that question directly as to what is included in our taxes and fees within the line items of our bill and what is not. I have been curious about if we were to look at a customer in Gresham versus a customer in Portland, would we see a disparity, or is the taxes and fees equal? I suspect they're equal, but I have no data to support that. I think, again, it goes back to a transparency and an industry for price setting.
And just to follow the logic, just to your last point there. So Gresham has adopted, one of these codes. If residents there are being essentially charged the same for taxes and fee as Portland residents, which it sounds like that's your assumption. We haven't tested the assumption, but we assume. In that scenario, then the carrier would be absorbing the difference in cost if there's a difference in cost between the city of Portland and Gresham. Assuming the city of Portland.
If Gresham was at a lower tax collection rate.
Let me be clear on my question. So if we're both assuming that Gresham and Portland residents are being charged the same for taxes and fees, right, on their bill, which I think was your assumption. I think that's a fair assumption in a market. If the city of Portland is charging a higher rate to the cellular provider than the city of Gresham is, then the cellular provider in that case would be absorbing the cost difference.
Well, I would argue differently, Commissioner, and say that customers from Gresham are subsidizing customers in Portland for payment of that fee that is assessed for small wireless.
And this is where the assumptions become important, right?
Sure.
Because I think we're going to hear it, just to preview it, that we're going to hear that that's leading, in such a scenario, that's leading to more investment in Gresham than in Portland if the cellular provider is absorbing those costs and not passing them on through to consumers. So that I understand your point, but that's the argument that
I guess I just want to clarify. If I was doing that cost study, I would look at the jurisdictional costs across the metro area, i.e. the 3 counties, add up my total annual payments to those jurisdictions and spread it across the number of customers within that jurisdiction and divide it by monthly, right? And so that would then average out across whether or not jurisdictional costs for fees for small cells were 1,000 or 1,800 in one jurisdiction, that wouldn't necessarily dictate my investment strategy. It just speaks to because I'm recovering the costs regardless, right?
I think you had me most of the way until the end, but I think for now, I'm ready. You know, when you're putting together a pro forma on investment and where you're gonna, you know, what markets you're gonna invest in, we certainly talk about this in housing, right? What are your upfront costs? What are you gonna be paying into a jurisdiction? It's not always the most decisive factor, but it is a relevant factor in choosing where to allocate dollars. And so, I think we're reaching the end of what we actually know, and we're making a lot of assumptions. So I just wanted to let's circle back to this as we go through the testimony.
Commissioner, I wonder, to kind of flip the question, is if we were to lower the cost of the small cell fee, would we see a reduction in bills, a tax on our bill?
Yeah, then it's a totally fair question.
Yeah.
Or would we see more investment
Yeah.
in 5G in the city of Portland? And it's like, that's I don't know the answer to the question. I suspect we're going to hear some, theories on it. I'm done for now.
So I want to ask a follow-up, because Commissioner Gonzalez has got my mind going here. And I want to make sure I understand, again, what this ordinance is and what this ordinance is not. My understanding, and somebody could very well make the argument that the total cost of investing in technology infrastructure in the city of Portland is higher than other jurisdictions for any number of reasons. The permitting fees are too high, the PBOT fees are too high. But this ordinance, what we are being asked to vote on, not today, by the way, it's a first reading, so when it comes back, is this $650,000. So the difference really would be whatever the delta is on our 650 versus what Gresham charges. Take the delta, the difference, and spread it over 650,000 people. That's what we're talking about here.
Yes.
And every dollar matters, and I accept that. But in terms of making massive multi-billion-dollar capital investments, this is de minimis. It's decimal dust.
Yes.
It doesn't matter.
Yes.
Unless somebody can tell me that I'm missing something that is in this specific ordinance related to fees, and I'm not seeing it. What I'm hearing in the testimony I have received, people made really good points, but it's not related specifically to this ordinance that we're being asked to vote on.
That's correct.
So unless somebody can convince me otherwise, I'm not seeing the hair on fire reaction to this ordinance. Anybody else before we go to testimony? Testimony. How many people do we have signed up?
9 people.
9 people, 3 minutes each. Name for the record, please.
First up, we have Alex Loop.
Welcome. Thank you for being here.
Thank you.
By the way, I should remind everybody, council rules, if you're a paid lobbyist, we need to know that. Thank you.
My name is Alex Loip, and I'm here representing Verizon. There's so much to get through. I probably can't hit it all in 3 minutes. I'm going to try to hit as much as possible, but I welcome
Before
any.
we start the timer, we
Sure.
will also accept written testimony since we're not voting today.
Okay.
Any written testimony anybody wants to provide that helps shed light on this, I personally would very much welcome it. So you don't have to feel
Thank
like
you.
you have to cram everything into 3 minutes of public testimony.
Thank you. Thank you very much. I appreciate it. So let me start here. So over the past 5 years, I've spoken with each of you about our goal to provide reliable, high-speed 5G wireless broadband service to consumers, households, communities, and small businesses throughout Portland. I wish I were here today asking you to approve of a right-of-way code that supports these shared goals, a code that was negotiated in a transparent, collaborative manner with stakeholders and conforms to the requirements of the FCC. Unfortunately, that code before you today does not meet those standards. This proposed code and rate structure will maintain the status quo in Portland, a status quo where companies like ours underinvest in digital infrastructure and instead deploy those capital dollars to cities that have reasonable policies and rates. I want to address the argument that the proposed code doesn't increase current fees and that the rates don't create significant fiscal impact for companies like Verizon. The truth is, while the proposed fees in front of you today have largely been in place since 2018, they are not cost-based, not compliant with federal law, and not backed up by a thorough independent cost study. You are being asked to adopt these problematic fees as binding city policy. It would create an untenable precedent for a wireless company to embrace Portland's rate, which is more than twice as high as the next highest rate on a West Coast city, not backed up by a rigorous cost study. We've included robust cost studies from San Francisco and Los Angeles in the packet that you hopefully have with you, as well as the Portland fee analysis that we saw for the first time on May 31st. And you can see for yourself that Portland really has not done its homework here. This fee analysis appears to us to be a reverse engineered exercise at best to justify the exorbitant rates that Portland has been charging since 2018, since before the FCC order went into effect and before the lawsuit against the FCC to maintain those rates. City staff has also argued the rate will go down as more small cells are deployed, which runs contrary to the notion of charging cost-based rates. Wouldn't additional small cells incur additional costs for the city, like for tasks like inspections? This is why a rigorous cost study is needed. I want to be clear. We are not insisting that Portland stick to the safe harbor rate of $270. Recognizing that cities have different costs, an apples-to-apples rate isn't the ask. We are insisting that Portland follow federal law and revert to the safe harbor rate until a cost study is conducted. In other words, show us Portland's apples. I do want to I know I'm over time here, I want to end just by thanking Commissioner Rubio for the amendments that she has taken. I think this is an example of the work we can get done if there is more time to work on this. We want to get this done, and we want to get this done right. And I respectfully request that you send this item back to the Commissioner's office for further work to address the other outstanding issues in the code and rates, and I look forward to returning here sometime very soon in support of that ordinance.
Could I just ask?
Of course.
Do I take it you do support the amendments? Is that correct?
Those two amendments are among the many we asked for, yes.
Okay, it's actually broken into three, but you get the point. Good,
Yes.
Thank you. Appreciate it. Thank you, sir.
Next up, we have John Isaacs.
Welcome. Thanks for being here.
Hello there, good to see everyone again. Mayor Wheeler and Commissioners, my name is John Isaacs. I'm the Vice President of Public Affairs for the Portland Business Alliance, resident of Southeast Portland. I prefer he, him pronouns. As I did last time I was here to testify about the City of Portland's seemingly addiction to high taxes and fees, I'm going to read directly from the Advanced Portland Economic Development Strategy that you had unanimously adopted about a month ago. On page 11, bring a resolution to City Council to require inclusion of a financial impact analysis when new regulations, policies, or taxes will have an impact on private parties to understand the full cost of companies bearing the cost. We will continue to push the city to remain accountable to this plan. It should and must be the guiding document if our city is going to thrive in the future. We strongly commend the council for doing exactly that with a strong stance against exorbitant new taxes and fees in the adopted 2023-2024 city budget. We ask today that you remain consistent with the fees for accessing the right-of-way. The numerous documents from city staff regarding this ordinance have argued that the city can charge the highest row fees of any major market on the West Coast. Fees that are the most expensive by a factor of 3 or 4 and are conspicuously identical to those charged before losing a case in federal court entitled FCC versus the City of Portland. They have never explained why we are so much more costly than everyone else, and I have not heard anyone within the city consider if this is in the interest of our residents who depend on these services to be available and affordable. In the year and a half we've been involved with this process, we have asked repeatedly for the city to transparently justify these out-of-market costs and to eliminate novel policies included in previous drafts of the ordinance. These sky-high costs ultimately result in higher energy bills, cell phone bills, internet bills, and other essential services provided through the right-of-way. And not only do these fees drive higher consumer costs, they are driving away investment in 5G, which is essential to Portland being competitive in the future. In speaking with one wireless provider representative about this recently, they said to me, maybe the council should ask why Redmond, Oregon has 5 times the number of small cell poles as Portland. We have sent you examples of cost studies conducted by other major West Coast cities. Our request is for the same transparent and thorough evaluation to be completed here. Only then will we be able to understand why Portland is so much more expensive than our competitors, so a pathway can be developed out of this position. I hope we can agree that being the most expensive city by a factor of 3 or 4 to deliver mobile or internet service is not something we should aspire to be. We appreciated the clarification memo sent to you last night by Bureau Director Donnie Oliveira, whose involvement has resulted in the elimination of many of the policy disagreements that existed last year. We greatly appreciate that his memo identified a few more sticking points that have been resolved here at the last minute. We agree with the memo that this ordinance does not directly set the fees, but we take issue with the bifurcation of fees between BPS, PBOT, and other bureaus as somewhat fuzzy accounting. To any company doing business with the city, this is one set of costs. And what better time to evaluate all of the costs, adjust them to be competitive, and bring them into one program than now when charter implementation is underway. And we don't actually know if the comparisons we sent are apples to apples with other cities because the city of Portland hasn't shown us its actual apples with a transparent and thorough cost study. Our ask of you is to give clear direction to city staff that the city complete a thorough cost study that identifies why Portland is such an outlier and presents a plan to bring us into line with other major West Coast markets. Whether through an amendment into the code or through a resolution, this addition will allay our strong concerns today. Thank you for your time.
Thank you. And John, if I could just make a point. First of all, thank you for the time and energy you and the PBA have put into this. And I did receive a very thorough letter from the PBA, and that helped me in terms of doing my due diligence and asking the questions I needed to ask. So I want to thank you for the time and energy put into that. I also just want to say none of the things that you're calling for are precluded through the passage of this ordinance. If we still want to talk about the other city charges that go into the development of any further access to the right-of-way, that's still very much on the table. We can talk about PBOT, we can talk about permitting, we can talk about the Bureau of Planning and Sustainability. In fact, those conversations are ongoing both through our budget process as well as other independent efforts that are separate from this ordinance. So that's my point. We can agree to disagree on whether this is the right time or not.
Can I respond to that, Mayor?
Of course.
Okay. So as I just said, we agree the ordinance doesn't necessarily set the fees. So we agree on that. As we stated in the letter, we think it's too much of an ask for any industry to sign off on a policy that's going to set how they interact with the right-of-way without having a thorough understanding of the cost. And as you're hearing already, and I think you're going to continue to hear, there's a gulf. I mean, it's not close of an understanding between the dialogue we just heard between you and city staff, who we've worked with all the time, and where industry is in terms of what the fees are. The analysis we provided, which comes from industry, reviewed by multiple attorneys, including the letter we sent, that went through multiple rounds of legal vetting by industry attorneys, are that Portland is 3 to 4 times higher than any other West Coast market. And as we've consistently communicated to all of you, our concern is our competitiveness and the dramatically rising cost of living here. So that's our main concern. That's how we've engaged in this, is that A, the policy is not novel, that it's consistent with other markets, and that we don't have fees that are that far out of market and are driving away investment and, as we've heard, potentially driving up the costs of essential services.
All right, thanks. Fair enough. I appreciate it. And I just want to reiterate again, as your letter acknowledged, and what makes this somewhat different than the last time you were at the dais is my opposition was to new taxes, fees, and utility rate increases. This, as your letter acknowledged, it's the same and has been for 4 years. So this is not an increase. So there's no additional burden being asked of our ratepayers.
Correct, but per the FCC order, that is a concern we have, that they are conspicuously the same as they were pre-FCC versus City of Portland. And again, to us, the way you answer the question is through a thorough and transparent cost study. I've heard statements from Commissioner Rubio today, which we really appreciate, Commissioner, and from Director Oliveira, that we'll work on that in partnership after this.
Yeah,
that's what's most important to
actually,
us. Yeah.
Just based on the fact that we don't seem to be agreeing on baseline facts.
Right.
I was provided one chart, for example, that I looked at that purported to be the cost of the city of Portland versus other cities, and I am no expert on franchise fee, but it was very easy for me to pick holes in it. So we really don't have a thorough baseline comparison. And that was provided as
There's
testimony to me as somebody who was in opposition to this particular ordinance. And that's part of why I went on my my earlier diatribe on this subject. But I'll let you go. Thank
Okay,
you.
thank you.
Thank you for the interaction. I really appreciate it, John.
Next up, we have Trey Hendricks.
Welcome. Thanks for being here.
Commissioners, Mayor Wheeler, thank you for the opportunity to speak today. I'd start by expressing my gratitude for the work and the opportunity to speak with your staffs. They've been incredibly responsive, generous with their time, open, knowledgeable, and inquisitive about our issues. And I would like to thank them for that, and thank you. When I heard that I would have 3 minutes instead of the 9 that I had planned in my comments, I had to make a decision about whether I would read my comments at triple speed or cut them back or just throw them out entirely. So what I'll try and do is maybe answer a few of the questions that you've asked. The reference to the $650,000 cost associated with administering this program strikes me that there's some kind of a disjunct between what the staff has been trying to do and what the actual impact is going to be on the companies. And for Ziply Fiber, who I'm here representing today, it would be significant depending on how the fees are calculated. Ziply Fiber has 58 miles of fiber in the city right-of-way. At the $5 a mile, or foot rather, we estimate it would be about $1.5 million a year in fees, which is significantly higher than the $650,000 cost associated with administering the program. And maybe that's a conversation that we still need to have with staff to sort of understand that. It's also possible that because Ziply is a utility provider in the right-of-way in the city, that it would be a gross revenue, I guess it's called a derived gross revenue calculation for the use of the fiber, which transits a significant amount of internet traffic. That number, we haven't done a calculation on that, but I would suspect it would be significantly higher than $1.5 million a year. And given that cost, I've been told by the company that in no uncertain terms, that if that were going to be the cost to stay in the right-of-way, Ziply would move its fiber elsewhere and probably abandon the Pittipicket building as a hub for its internet traffic. It would just simply be too high of a cost for a company with a 4-state footprint. And then the final point that I'll address is digital equity that Commissioner Gonzalez raised. And we also think that's critically important. As you may be aware, the broadband office in Oregon is conducting a rulemaking to determine how hundreds of millions of federal dollars are going to be spent to help get enhanced broadband access to underserved Oregonians, and in Portland as well. This will add to the costs associated with building those projects, and because there will be matching requirements to get that money, it could have a pretty chilling effect on companies' ability to do those builds. And that's really a statewide effect as well as Portland and surrounding communities. So what we're essentially asking for is that we have some additional really thorough vetting process in written comments and stakeholder workshops where everybody can get together and have that conversation and try and clarify some of these issues. And I can take questions, and thank you again.
Great, thank you. Appreciate your testimony. Thank you.
Next up, we have Alan Galloway.
Welcome. Thanks for being here.
Good afternoon, Mayor Wheeler and honorable commissioners. Thanks for having me. My name is Alan Galloway. I'm an attorney at Davis Wright Tremaine. I am pleased to be here today representing T-Mobile. T-Mobile supports many of the city's expressed goals with respect to the ordinance, but opposes the ordinance as written, and I want to explain why, as we did in our comments. First, I just want to note that we've tried to engage with the city from the outset. T-Mobile has now submitted 3 rounds of formal comments and worked with the wireless industry to try to discuss concerns and raise concerns about federal law with staff throughout the process. I really want to appreciate, Commissioner Rubio, the amendments that you announced today. Those are a further step in the right direction. I also want to appreciate that staff has done a lot of work on this, and I know that this is not easy. I know the federal law on this is not necessarily the easiest to understand. While the process has gone a long time, I don't feel that we've made a lot of progress until recently. Recently, things have started to change. The last draft was a small step, but a significant step forward towards compliance with federal law. And I want to appreciate the fact that the new draft appears to take steps to clarify that fees on small wireless facilities and other wireless facilities are going to be facility-based, that they're not going to be subjected to the gross revenue fee that was stated elsewhere in the ordinance. And T-Mobile appreciates that step. That step is necessary, in fact, to comply with federal law. Under federal law, it is unequivocal that fees must be cost-based. That is required by Section 253 of the Communications Act, and with respect to wireless facilities, it's also required by Section 332, as we've explained in our comments, and I invite you to read those. The fees in the fee schedule currently, it's not clear that they meet the requirement that they be specifically related to and caused by the deployment of wireless facilities, and that they are not only a reasonable approximation of the city's costs, but that the costs themselves are objectively reasonable. Although the city has very recently provided a small cell fee analysis just this past week, that document doesn't have enough detail to tie those costs to deployment in the right-of-way, doesn't have detail supporting the city's allocation of costs of salaries and personnel, and it doesn't have any showing that those costs are objectively reasonable. So more work needs to be done in this area. The city should also revisit the lease consent requirement, which is an obstacle to deployment, as we've stated in our comments, and should revise the burdensome and unreasonable indemnification provision in the current code that indemnifies even where there's no fault or no unlawful conduct by the provider. Requires the city to be indemnified for its own negligence. That's not fair. We recognize that this has been a long process. Again, I would like to also be able to say we made a lot of progress. I think, though, that we are beginning to make progress. I think that there is a possibility that with the current staff and the willingness that has been shown today to address some of our longstanding concerns, the definition of small wireless, thank you, we could get this right. But it is going to require a little bit more time. T-Mobile would be happy to work with the city to do that and to make this code the code that the city deserves, to encourage the wireless service that the city deserves. Thank you.
Thank you.
Happy to take any questions if you have some. If not,
Thank you.
all right, thanks.
Next up, we have Jeremy Crandall and Christine Crow online.
Welcome. Great. Can you hear me okay?
Yep, loud and clear, and we see you as well.
Excellent. And I don't see the timer, but I'll you can bear with me. I'll just do one myself right here so I don't go over. Mayor Wheeler, commissioners, my name is Jeremy Crandall. I'm here to there we go. Thank you. I'm here to testify on behalf of CTIA, the Wireless Industry Trade Association, with some comments and concerns related to this ordinance. My colleague, our legal counsel, Christine Crow, will speak after me. Together, we'll briefly summarize our perspective on several key elements, and our perspective is also more extensively outlined in our submitted letter that's in your portal. I will also just thank you all for the ability to speak on this ordinance virtually from Washington, D.C. Let me begin by saying that CTIA and our members are strongly committed to doing what we can to improve connectivity for residents and businesses across the city. As we all learned during the pandemic, innovations in telehealth and distance learning required enhanced, reliable mobile connectivity. Cities, residents, schools, and businesses and institutions can continue to demand exceptional wireless service. And so our members are committed to ensuring that no community is left behind. I heard the conversation about digital equity. We're doing that by investing tens of billions of dollars right now in infrastructure nationwide, $35 billion in 2021 alone in private funding to upgrade, upgrade our infrastructure. And that investment fuels economic growth in Oregon, where our industry supports more than 50,000 jobs, generates $17 billion in annual GDP growth. Our members are doing everything they can to work with state and local officials to build those networks. And responding to this exploding growth does require policies that ensure regulatory predictability for our members. I do want to speak on one example specifically where we believe the ordinance creates some needless and unnecessary barriers and challenges for deployment. Again, it's outlined in our letter, but one example is the code is drafted presently would regulate service providers that do not install any equipment in the right of way, but merely use others' equipment. For background, a wireless provider may often send its traffic over another provider's physical network or resell the services of a provider within with facilities in the right of way. And so when this occurs, it imposes no essential burden or cost on the city in terms of right-of-way management, because it does not require installing antennas, fiber, or other types of equipment. And as such, it would seem to make little sense for Portland to subject those providers to licensing, fees, insurance, audits, and other requirements of the proposed code. A more sound approach that does not include this provision would in fact encourage our providers to use the facilities of others, and that would minimize the number of separate facilities occupying the right of way, which is something that I know many folks believe is very important. So in closing, given the exploded demand we are seeing from consumers for more services, we'd very much encourage you to adopt policies that encourage rather than derail investment. And I know our members are eager to continue collaborating with you all on that front. I'll stop there. Thank you.
Thank you. Appreciate your testimony.
Next up, we have Christine Crow.
Hi, Christine.
Hello. Mayor Wheeler, commissioners, thank you for allowing me to testify. My name is Christine Crow. I am with the firm of Wilkinson Barker Nauer LLP. I'm located in Washington, D.C. And again, I am testifying on behalf of our client, CTIA. Mr. Crandall raised several policy concerns about the revised code. I'd like to address 3 additional concerns that are expressed in the letter that CTIA filed in anticipation of today's hearing. First, the fees for wireless facilities the Bureau asks you to enact do not comply with federal law because the Bureau has not demonstrated that the fees don't exceed the reasonable, actual, and direct costs associated with rights-of-way management in connection with these facilities. We therefore ask that you not adopt the proposed fees and instead require that fees be consistent with federal law. As background, the fees, the proposed recurring fees far exceed the amounts that the FCC determined in 2018 were reasonable, amounts that a federal appeals court upheld. Although the Bureau just days ago attempted to justify the fees for small wireless facilities with a one-page spreadsheet, it did not give providers any meaningful opportunity to respond. It makes inconsistent and unexplained assumptions about costs, and it supplies no basis for fees for larger wireless facilities either. In addition, as CTIA's letter explains, the 5% gross revenue fee that is proposed for communications service in the fee schedule, which the Bureau has declined to date to confirm explicitly will not be assessed on wireless providers. For example, those wireless providers who lease space on others' facilities within the rights of way, also violates federal law. Revenue-based fees have long been rejected by courts because they are, by definition, not cost-based and may have the effect of prohibiting service. Second, the code unlawfully restricts a wireless provider's right under federal law to determine whether to lease spectrum capacity on its facilities or to make physical space on its facility available to other providers. Portland should encourage these practices because they can minimize multiple right-of-way installations and promote competition. We thus ask that these restrictions be removed from the code. Third, the indemnification obligation is overly broad and would require providers to indemnify Portland based on the mere presence of facilities in the right-of-way. The provision goes far beyond what indemnification provisions typically cover. It would render providers liable simply for lawfully operating in the right-of-way, even though Portland had approved that operation. It should be limited to cases of negligence or wrongful acts by providers. Given these issues and others that have been raised with you today, we ask that you defer adopting the code at this time and ask that the Bureau consider these concerns. Thank you.
Thank you. Appreciate your testimony, and thanks for hanging late with us DC time. Thanks.
Next up, we have Daniel Schweitzer.
Hi, Daniel.
Good afternoon, Commissioners and Mayor. My name is Dan Schweitzer, and I am on behalf of Crown Castle, the nation's largest shared communications infrastructure provider. Currently in the city of Portland, we have 23 small cells and 75 towers. I want to thank you for this opportunity to provide testimony today on the proposed ordinance, which adds a new Title 12 to the city code and address usage of the public right-of-way by utility operators. We appreciate that the city's stated intent is to streamline the franchise process for all users of the public right-of-way. However, as a provider of critical infrastructure located in the right-of-way, we are concerned that what is being considered today violates federal law and that the fees imposed conflict with the 2018 FCC order, which, as you know, has been upheld by the Ninth Circuit. Specifically, communications infrastructure providers who build small cells in the right-of-way that are connected by fiber that also is located in the right-of-way, we are concerned that the fees proposed by this legislation are not cost-based, and there is some question as to which fees would be applied to Crown Castle and which fees would be imposed on the customers who utilize our facility to provide the wireless service that we all expect and rely upon. Is the city intending to charge Crown Castle separately for the small cell attachment that it installs on vertical infrastructure in the right-of-way, as well as the fiber that connects the small cell nodes? Or is the fiber included in the small cell attachment fee as we believe it should be? It is not clear in this legislation. Furthermore, is the city intending to charge our customers for usage of our infrastructure? As a reminder, each fee imposed on a telecommunications infrastructure provider in the right-of-way must be cost-based. Fees based on a percentage of gross revenue or linear foot fees are not cost-based, and we strongly encourage you to revisit these sections of your code and bring it into compliance with federal law. We have requested clarification from staff and from each of your offices, and to date, no one has been able to answer these critical questions. In fact, it was suggested that a workshop be convened after this ordinance is adopted to work through the fee details. We believe that it would be prudent to understand the cost before this legislation moves forward. So I've spent a little bit of time talking about some of the technical aspects of the ordinance, but really I want to also cover some policy aspects. And the first one is that telecommunications networks are a part of a robust economy and can be a driver for growth. Two, health and safety considerations cannot be ignored in regards to connectivity. Today, over 80% of 911 calls and emergency services are made from wireless devices. And third is this ordinance as drafted is out of step with promoting communications networks in a modern city and seriously inconsistent with other cities. For these reasons, I believe we should press pause on this ordinance and convene industry stakeholders and city staff to create a lawful and efficient set of guidelines concerning the deployment of communications networks within the city.
Thank you.
And if I have just a few seconds to speak, Mr. Mayor, one of the questions you asked was that you're just not seeing it. And I have a serious concern about $4.95 linear fiber fee for existing fiber. I don't understand. The city recovers its cost fully through the permitting process. The installer lays fiber. We are on the precipice of a large small cell deployment in the city of Portland. This ordinance will almost surely prevent it, and almost certainly just on the fiber alone. We really need to understand how the city is incurring annual ongoing costs with having existing fiber underground. Those fees have already been fully recovered through the permit process. You deploy 100 or 200,000 feet of fiber, that's $1 million of unbudgeted OpEx that the city is collecting, and the reasons are unclear because we haven't seen the work.
Good. And that's an interesting point, and I'll ask, not necessarily today, but could we follow up on that question? Because that's an interesting one to me, too.
If I'm misreading it, I hope I am. If the fiber that's feeding the small cells is exempted from the fee, as it should be, because it's pertinent to a small cell facility, it's a different conversation. Others may have concern. But as drafted, it's unclear at best.
Okay, thank you for that.
Thank you very much.
Yeah, appreciate your input. Thank you.
Next up, we have Sophia Steele online.
Welcome.
Yes, well, good afternoon, Mayor Wheeler and Commissioners. My name is Sophia Steele, and I represent the Western States Petroleum Association. We have member companies that operate in the city of Portland and supply much of the fuel used throughout the state. Members of this city council and residents of Portland have shared their desire to prioritize clean and safe energy. WISPA and our members share this desire. Unfortunately, we're here today in opposition to these updates, and we have specific concerns with the provisions addressing the fuel pipelines. As you know, pipelines provide the safest, cleanest, and most efficient means of transportation of liquid fuels. Some of these proposed changes interfere with the operation and maintenance of existing fuel pipelines, as well as discourage the construction of new pipeline infrastructure, which will be needed for growth and the energy transition to renewable fuel products. When considering the shared goal of clean and safe energy, we respectfully request the changes to the fuel pipelines be removed. Thank you for the opportunity to testify and share our comments. And Mayor Wheeler, I should mention, we did file a more formal letter with all of our concerns outlined in detail.
Awesome. Thank you. I appreciate that. Thank you for doing that.
Thank you.
Next up, we have Skip Newberry.
Hi, Skip.
Mayor Wheeler, members of City Council, my name is Skip Newberry, and I'm President and CEO of the Technology Association of Oregon. We're based in Portland, and I live in Northeast Portland. We're testifying today in opposition to the proposed rules governing right-of-way, specifically with respect to how calculations of fees have been conducted. We've already submitted written testimony, so I don't need to belabor those points. Now, I think productive conversations have been underway since the rules were shared at the end of May and even before that. And as demonstrated today, I think by some of the amendments that were offered up, I think good work is undergoing. And we applaud city staff as well as you all for your work on that. This is a complex area. In terms of the issues that were raised today around exactly how the underlying facts were arrived at, there's some questions, right, in terms of some of the underlying assumptions as it relates to how the fees were calculated. And we think it's important to get the policy right, given what's at stake, both for area businesses and residents. We're all in an increasingly digital world, and it's important that we take the time now, I think, to make sure the policy is as good as it can be. Also wanted to just mention that we agree with other testimony that's been provided today as it relates to a logical next step being a transparent cost study, and in particular looking at how that might compare to other West Coast cities that we're often competing with for businesses and, frankly, residents as well. So thank you for your consideration.
Thank you, sir.
Yep.
Our last testifier is Bridge Crane Simca.
Welcome.
I'm Bridge Crane Simca, Charles Johnson, and I'm sure that's been crystal clear to everybody, everything we've just heard. However, the good part was that Crown Castle was here, because I don't think people really understand what the FCC is insisting we can't regulate. Old high school franchise fees are fading away. What we're witnessing right here now is that Verizon and T-Mobile are engaged in a customer war with Comcast. They want to see Comcast subscriptions fall as people switch to 5G. These companies are experts. They're going to extract that money from us. It is possible that, 2 years from now we'll sit back and go, oh my God, broadband in Portland costs 1.7% more than it costs in Seattle. I don't know if that's a very determining factor. Maybe it'll turn out to be less. But you have, it's been a long time since I talked about whether we have more than 40 city attorneys that have looked at the Ninth Circuit's opinion about what the FCC says. And they seem ready to go. We had a different agenda item where when we get into federal litigation, sometimes you have to scooch a few $100,000 out the door to private counsel because the city attorney's office doesn't feel ready to go to the Ninth Circuit. But connectivity will not collapse if you approve this. Crown Castle will continue to put towers in. They'll put a tower in, and then some Verizon equipment will get hung on there, or maybe just they'll put equipment on there and they'll lease that equipment to Verizon, and Verizon won't even own it. And then possibly T-Mobile will hang some equipment right on the same tower. The FCC has told us that doesn't matter. Localities can only look at the right-of-way impact. You had two staffers come up and say that small cell is, you can word it either way. You can revert it as a great service provision opportunity, or, of course, the reason the companies are doing it is not because they want to provide service. It's a revenue for them. They think that they can make a lot of money selling little Verizon boxes for 5G. So if you feel like the city attorney's office has had a reasonably talked with you about the Ninth Circuit's opinion on how the federal rule applies to what you can regulate and where you can't take gross revenues from, you can pass this. There's a chance you'll get sued. But hopefully there's been some briefing about potential costs of litigation in this matter. As you spent many minutes talking before, we have this question of why all the hoopla when these are not the actual fee schedules, although we've heard about cost per mile or what on fiber. Good luck to y'all, but it's not as apocalyptic as it sounds.
Thank you.
That completes testimony.
Very good. Colleagues, any further questions? We will get to the amendments today, and then we're going to pass it on to second reading, but did anybody have any follow-up questions for staff? Great, terrific. I want to thank everybody who testified. It was excellent testimony. I look forward to having more conversations over the course of the next week, so thank you for taking the time to be here. With that, then, we'll get to Commissioner Rubio's first amendment. This was the directive that this ordinance meets the requirements of a prior resolution regarding work sessions and executive sessions. Any further discussion on amendment number 1? Please call the roll.
Ryan?
Aye.
Gonzalez?
Aye.
Rubio?
Aye.
Wheeler?
Aye, the amendment passes. The second amendment revises the definition of a small wireless facility as defined by the Federal Communications Commission. Any further discussion on this amendment? Seeing none, please call the roll.
Ryan?
Aye.
Gonzalez?
Aye.
Rubio?
Aye.
Wheeler?
I just want to thank Commissioner Rubio and her team as well as the city team for working with industry. I should have said this on the first one. On all three of these, I appreciate that. I vote aye on the amendments adopted. And last but not least, Amendment 3, it adds a new subsection to the utility-specific provisions code in Exhibit A. Any further discussion? Please call the roll.
Ryan?
Aye.
Gonzalez?
Aye.
Rubio?
Aye.
Wheeler?
Aye. The amendment is adopted. This is a first reading of a non-emergency ordinance. It moves to second reading as amended. Thank you, everybody. Next item, 472, please.
Amend the Planning and Zoning Code to adopt vehicle parking reforms to comply with state rules.
Colleagues, today we're holding a hearing on parking compliance amendments project. This project is being brought to us by the Bureau of Planning and Sustainability, so I'll pass this over to Commissioner Rubio. Commissioner Rubio.
Thank you, Mayor. I'm pleased to introduce this ordinance that proposes zoning code amendments to bring the city into compliance with the new state of Oregon parking rules. The rules are intended to support the state's goals for reducing transportation-related pollution, which accounts for approximately 38% of Oregon's climate pollution. They were adopted by the state, and all cities must comply by the end of this month. The project removes minimum parking requirements citywide and adjusts parking maximums and parking lot standards to bring the city into compliance with the state's new rules. And I'd like to thank the staff for their great work on this. I would also like to thank the Planning Commission for forwarding the recommendation for our consideration. This is the first recommendation we've received from the new Planning Commission since its formation early this year. Before I pass this on to staff to begin the presentation, I'd like to introduce a package of 3 minor technical amendments. Staff brought the need for the amendments to my attention and have submitted a memo into the record dated June 2nd, 2023. These amendments were included in the clerk's Tuesday memo for council and the public to review in advance of this meeting. The amendments bring the city into compliance with even newer updated rules adopted by the state earlier this spring that are more feasible to meet. I've asked the staff to explain the technicalities. So Sandra, can you please share the details and show us the slide with the proposed amendments?
Yes, thank you. Good afternoon, Commissioners and Mayor. My name is Sandra Wood with the Bureau of Planning and Sustainability. I'm the Code Development Manager. And the 3 amendments that Commissioner Rubio was describing are on the slide before you. The amendments basically change the rules to development standards that apply to parking lots. that advance what we would consider green features of those parking lots, and they would only apply to large parking lots. In essence, these changes reduce the regulatory requirements for parking, for which parking lots need to meet the green feature standards, and reduces the requirement for tree canopy coverage from 50% to 40%. The actual changes to the code language are shown in the parking compliance amendment project as amended draft that has been linked in the item on the council agenda. Next slide, please. And as a part of housekeeping, part of the amendment is to replace what we originally filed as a council filing, which is the Planning Commission's recommendations, with new documents that show this amendment reflected in the new documents. We wanted to thank Commissioner Rubio for bringing this, for moving this amendment forward, especially before the testimony. We appreciate you making this change, and it brings us back into an alignment with the state rules. With that, I'll pass it on to J.P. McNeil. He is going to present the Planning Commission's recommendation.
Should we vote on the amendment first?
I think you need testimony first.
Oh,
yeah.
Okay, so just to be clear, these appear to be technical amendments. Would you describe them as such?
Yes.
Okay, very good. Why don't we put them on the table for
Okay.
discussion? Do you want to move?
Yes, I
and
move that the council move the amendments as described and replace the documents shown on the slide.
Can we do them as a slate, or do we need to do them individually?
Do you need a second?
As a slate was what the city attorney said we could do.
Very good.
Second.
Commissioner Ryan seconds. The amendments are on the table. Thank you.
Great, thank you. And then the public, hopefully, can testify on them. And we've posted them on our website last week.
Yeah, great.
Okay, good afternoon, Commissioners, Mayor. I'm JP McNeil. I'm a planner with the Bureau of Planning and Sustainability, and I'm going to talk to you about the Parking Compliance Amendments Project. This is a response to mandates for parking reform in the state's climate-friendly and equitable communities rules, or just climate-friendly rules for short. Next slide, please. So there are three, as a quick overview, there are three main proposals with this project, and they are to remove minimum parking requirements citywide, to update and simplify the maximum parking requirements, and to add some new development standards for large parking lots. Next slide, please. So the first proposal is to remove the minimum parking requirements across the city. As of now, there are only a few remaining areas in the city that still have minimum parking requirements. And so this project proposes to remove them to comply with the climate-friendly rules. That's the bulk of this project. And I'd also like to point out that removing minimum parking requirements does not equate to no parking with future development. Developers can still build parking. It just means that the amount provided isn't set by the code, but it's determined by the market. So next slide, please. This map illustrates the areas where minimum parking requirements are proposed to be removed in purple. So the areas where we're talking about, where we're removing minimum parking requirements, are generally on the outskirts of the city. It's largely industrial land, parks, and open space. And because of that, the impacts are minimal because minimum parking requirements have already been removed in most areas of the city. And as I said before, parking, it's not prohibited. It can still be provided to accommodate uses as needed in these purple areas. The next proposal is...
Next slide, please.
Oh, sorry. The next proposal is for the maximum parking requirements. In the rules, the state requires cities to adopt maximum parking requirements. Portland largely complies with those rules already. We have maximum parking requirements in place because of metro rules, and so we're just updating our maximums to align with the state rules and simplify some of the parking ratios. Next slide, please. The last proposal comes in two parts. The large parking lot development standards. The first part limits the size of surface parking lots for buildings that are larger than 65,000 square feet in size. So think of a big box retail store. And so in that case, the surface parking lot can be no larger than the building itself. So a 100,000 square foot building can only have a surface parking lot of 100,000 square feet. Next slide, please. And the final piece of this is the large parking lot green features. As Sandra mentioned, so currently, as proposed by the Planning Commission, it applies to parking lots over a quarter acre in size. One of the amendments is to up that to half acre in size to trigger these requirements. The requirements that are triggered are to either incorporate tree shading for new, larger parking lots, solar power generation on site, or for public buildings that can meet green energy building requirements that currently exist, but that only applies to public buildings. And then the second piece to this is that access ways, the major travel routes to a parking lot, need to include trees along the edges and pedestrian pathways along the edges of those access ways. The reason we're here today, I've mentioned previously about the climate.
Next slide,
Oh,
please.
sorry. Just do that. The reason, as I mentioned, the climate-friendly equitable community rules, the state adopted those last summer, and they require communities to update their land use and transportation plans to support the state policies to reduce Oregon's greenhouse gas emissions by 75% by 2050. So the project is in alignment with that. It's also in alignment with city policy as well, including several comprehensive plan policies related to reducing parking demand and managing the supply of parking to limit the development of off-street parking for land use and transportation and environmental goals. Next slide, please. Our community engagement for this project has been, it's a compliance project, and we have a short timeline. It needs to be adopted by, in effect, by June 30th. So we were pretty limited on our time frame, but the states had a 2-year engagement process for the climate-friendly rule, since this is a state mandate. So much of the engagement took place at the state level. Locally, we reached out to the district coalitions and some neighborhood groups. We met with the ones that asked for a meeting. We asked the district coalitions to send notice of the project to the neighborhood associations in their districts. We also presented the proposal to several of the public commissions, the Design Commission, Historic Landmarks, and we also had a public hearing at the Planning Commission on April 11th, 2022. And here we are.
23.
Oh, yeah, you're right. Yeah. And then the public hearing today at City Council. And with that, I'm going to turn it over to Sandra for some housekeeping.
Yeah, so at this point, we did have some pieces of written testimony. I think there's 8 pieces of written testimony in the map app for this project before you. And there's additional evidence in the project record on the auditor's website. Next, please. So what we're asking the City Council to do is to consider the Planning Commission's recommendation, and the procedure would be to vote on the amendment that Commissioner Rubio put on the table, and then to vote to approve the emergency ordinance, which adopts the as amended draft and amends the zoning code. As JP mentioned, we do have a June 30th deadline per the state, and that's why we're proceeding with the emergency ordinance. Thank you.
Thank you. Colleagues, any questions? Public testimony?
We have one person signed up.
Very good.
Katie Gould.
Hi, Katie. Thanks for being here.
My name is Katie Gould. I'm a senior transportation researcher with Sightline Institute, and I urge you to vote yes on this proposal. And I know there's not a lot of controversy around this, right? I'm the only person testifying about parking. That's new. But I wanted to take a moment to acknowledge the historic moment that we're in right now. Over 6 years ago, back in 1959, Portland began requiring predetermined amounts of parking for every new home, business, civic institution as a condition of development. These rules have blunted home construction, they've killed small businesses, and they've forced new buildings to be literally designed around cars. We've long been aware that these rules are problematic, which is why we've made so many exceptions to them over the years. There are so many carve-outs for parking mandates today in Portland that even the most ardent parking reformers would say were essentially eliminated. But these rules are still on our zoning code, and other cities are still copying us and those codes that are in there today. Because Portland has long been considered a really good leader in good urban planning policy. Which brings me to today. Because of this state action, we can finally leave these regulations in the past where they belong. That being said, when parking controversy has happened, I'm thinking specifically a decade ago when I first moved to Portland around Division Street. This city council has looked to parking mandates as a solution to resolve people's concerns about street parking. And while that's maybe good politics, it's actually done very little to solve people's actual parking issues. So moving forward, now that we don't have this tool, we need to be more comfortable using the other tools in our toolbox that actually work, like meters and permits. And I would urge the city to take a more proactive role in managing its parking supply in the future and implement the pricing policies that have already been recommended by the POEM Task Force. Thank you.
Thank you. Appreciate your testimony. Thanks for being here.
That completes testimony.
Very good. This is an emergency ordinance. If there's no further questions, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
I want to thank, again, BPS staff for all their great work on this. And I'm also grateful that our cities.
I'm sorry. I forgot to vote on the amendments. Can we hold on the vote?
Okay.
Let's go to the amendments. Please call the roll on the amendments.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
All right, so the amendments are on the table. Commissioner Ryan, do you want to keep your vote where it was?
Yeah, but do I have to do it
Why don't we just let's
do it again
Sure.
otherwise.
make it clean? Exactly.
Yep. Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Thanks again to the BPS staff who worked on this and for all your great work. I'm really grateful that we live in a city that has already done a lot of the heavy lifting and on a lot of parking reforms. So the changes in front of us, while they're significant, it also feels in many ways like minor code cleanup because of our progress so far. So this is just one of the many things we're doing to move Portland forward, and every part counts. I vote aye.
Wheeler.
Aye. The ordinance is adopted as amended. Thank you all. Back to the regular agenda, second reading, item 473, please.
Amend City Code to update existing public camping restriction policies to comply with House Bill 3115.
Colleagues, this is a second reading of the time, place, and manner ordinance council heard last week. We had substantial public testimony on this item. I want to thank everybody in the public for your engagement. We had almost 200 people sign up to testify in person. We have received almost 700 written comments. Council did not have the time to hold a discussion on this item last week, so I'd like to welcome my colleagues to ask any questions or share any comments they may have. Staff is here to answer any questions. Why don't we have staff come up just so we're here and ready to go in the event that anybody has follow-up questions? Colleagues? I may have just made you walk up here for no apparent reason, but at least you got to stretch your legs. Very good, colleagues. Any other, we've had public testimony, we've had the staff presentation. Any further discussion on this item? Seeing none, please call the roll.
Ryan.
Yes. Last week, we had lengthy testimony on this ordinance, and since then, thousands of Portlanders have submitted written testimony and comments. Every day, I talk to tenants, property owners, employees, families, and elders who no longer feel safe in our city. Portland, you have been patient. I hear you. Your patience has run out, and the status quo is not working. We are building a robust system for those who wish not to be homeless. We are committed to accelerating those services, and we will continue to push Multnomah County to deliver more as they own and fund these services. As leaders elected to serve this city, we must be honest with ourselves. There are many people on our streets who refuse these services. For those refusing, we need to stop enabling and allowing people to do illegal things on the streets. We need accountability. We must continue to differentiate those who are ready to receive services so we can help them quickly by building resilience and expediting the transition into housing and life off the streets. For those suffering from addiction and refusing services, we need to send a message that Portland is no longer a safe haven for criminal behavior, and crime will not be tolerated. This proposal focuses on the homeless community that refuse services. To our day service providers like Rosehaven and Blanchet House who testified last week, I hear you. Local government must provide more support for your operations to ensure those who need somewhere to go, somewhere to be during the day can find respite. As poisonous drugs take over our city and our great state, the city, the county, and the state must align efforts to take urgent action that impacts our ravaging people in ways no one has seen before. The first step to recovery is to admit we have a problem. The mayor's proposal demonstrates an honest, thoughtful, and balanced approach to managing public spaces. Portland's best days are ahead of us. With hope for recovery, I vote aye.
Gonzalez.
I am going to vote aye today. As mentioned last week, I'd hope to strengthen the mayor's proposal. I do have some concerns about the complexity of it, what that means for implementation, but we're not going to let perfect be the enemy of the good. This is a step forward. If the city commits to actually carrying out on enforcement, it will improve things on the streets of Portland. I feel very strongly about this, and I'm just going to reiterate the reasons why. A particular focus is on criminal behavior that has occurred at times in the city of Portland. It is not targeted towards those that are suffering from economic upheaval that we need to continue to support on our streets. The homeless problem is complex. It is multifactorial. There are multiple segments within that population, those that we need to continue to offer a helping hand to, and then others that we need to drive out of the city. And when we talk about driving out of the city, that's criminal behavior. We did receive a lot of positive support for our amendments, but there isn't sufficient political support at this time. So we decided not to pursue. And to my colleagues, I hope we can continue to keep focus on improving safety and livability in the city of Portland, the city we all love. We're going to have some tough conversations. We will have, at times, very vocal minorities that will oppose what is the right thing to do. But this ordinance, this change in code is a step in the right direction, so I vote aye.
Rubio.
I want to thank everyone who's called, testified, emailed, and written about this important issue. As I've shared with the mayor's staff who've graciously spent a lot of time with me and my staff on this issue, I'm voting no today, and here's why. The spirit of this ordinance is to balance the very real need to get more people into a variety of shelter options and the safety and livability of neighbors throughout our city. And that is a hard balance to strike. I hear, know, and understand the concerns that we all face when we are seeing crime, livability issues, trash, and all the concerns that people very validly have. Nothing about this work is easy. And that's why I want to lift up the hard work of staff and of city and county employees, from Street Service Coordination Center to Safety Net and first responders to Project Street Response, and everyone else who are out in our city every day working with our houseless community members and working to make sure our city is ensuring accessibility, safety for all Portlanders. I also know that the mayor's intent here is not to put in place a green light to arrest people. That I don't doubt, but for me, I need to see that this ordinance is planful about its impact and does not cause harm. As I said last week, this council had a public discussion last year about our values related to camping bans. And while we agreed a policy would be need to discuss and put on the table in the future, we also committed to exclude any provisions that would criminalize people solely for being homeless. And it's not clear to me at this time if this ordinance maintains that commitment. I do believe that with some time and alignment, we have had an opportunity to get this right, and by giving all people involved, whether that is neighborhood associations, shelter providers, police officers, security officers, houseless folks, an ability to truly understand the implications of this ordinance and make plans to address gaps accordingly. For example, I would have preferred that our timelines match with the increase in available shelter sites. I would have preferred to give our shelter providers time to understand and adjust their daytime capacity accordingly and bring in new partners for additional capacity. I would have preferred to give our new training dean, who starts tomorrow, the time they need to train our officers, not only in the details of the ordinance, but also on our expectation that any enforcement mechanisms will be carried out with dignity towards our in-house neighbors. And finally, time for providers and houseless individuals to know what is in place so that when things do go into effect, there is a shared understanding about where people can go or be referred to. And I think one suggestion that we heard last week was a resource list or map, which I thought was a good idea. But to move the policy forward before all these pieces are ready to go does not make good or responsible policy sense as I see it. The success of us solving the houseless crisis rests in our ability to work together jointly, not siloed. And this feels like a unilateral action by the city instead of in partnership with others. Not doing so creates an us versus them situation, as we saw play out during testimony last week. And I know that we're all tired and saddened by this narrative. Finally, before I cast my vote, I want to be very clear that I continue to support the temporary alternative shelter sites with services to bring the stability houseless community members very much need. And I stand with the mayor 100% on this and will do all I can to ensure its success. In addition, my team continues to work to speed up housing production, to build a fuller continuum of supports for many different individual needs, and to provide a path away from the houseless crisis. We need to do all of the above, and I'm committed to everything we are doing except for this one step. I vote no.
Wheeler.
Commissioner Mapps had asked if I could please read a statement on his behalf before I give my voting remarks. He asked that this be read into the record. This is Commissioner Mapps. I support this time, place, manner ordinance. I thank the mayor and his staff for leading on this critical issue. This ordinance aligns us with House Bill 3115, but more importantly, it reinstitutes enforceable rules and expectations for our streets. Portlanders have been consistent and they've been clear. Unfettered camping and the behaviors that accompany it are unacceptable. Until the pandemic, when we were heeding CDC guidance, Portland had never allowed rampant street camping. We didn't allow it for obvious reasons. It creates a public health and humanitarian crisis that is inherently unsafe for everyone. I see this ordinance not only as an end, but as a beginning. Portlanders are compassionate people and want folks to transition off the streets into programs and solutions that work. While today we're making rules regarding where involuntarily homeless can and cannot camp, we're also working tirelessly on alternative shelters that are resource rich and safe. We will undoubtedly need a significant increase in sobering, detox, and inpatient drug and mental health residential treatment. Again, I want to thank Mayor Wheeler for this clear-eyed and thoughtful resolution to the problem of unmanaged street camping. That's from Commissioner Mapps. These are my remarks. This update to our city code is necessary to comply with state law and with Martin v. Boise 9th Circuit decision. I want to thank Governor Kotek for her work on House Bill 3115, the state law that requires us to update our code and give clear guidance regarding camping in the city of Portland. I also want to thank Governor Kotek as well as Chair Vega Peterson for their incredible leadership and partnership as we stand up necessary shelters and services in the form of our temporary alternative shelter sites as well as the existing Safe Rest villages. These reasonable restrictions, now codified in city code, updates existing city code and incorporates language from the recently completed ADA settlement. The proposal also builds in a warning system before any penalties are applied. We've also worked in partnership with our city bureaus that operate within this space to ensure that the enforcement process of this ordinance is both successful as well as credible. The next few months will be focused on education as well as outreach, with an emphasis on ensuring the homelessness navigation outreach teams have the clear and thorough information that they need on this new ordinance. My team will also work with our civilian training dean, who starts tomorrow, on including the operations and enforcement related to this ordinance in all training and education for our Portland police officers. These reasonable restrictions, coupled with our work on increasing shelter availability along with access to services, are a step in the right direction towards a revitalized Portland. I want to personally thank my staff, Skylar Brocker-Knapp, who is here, as well as Sarah Morrissey, my Deputy Chief of Staff, and indeed the entire staff in the Mayor's office for their long-standing and tireless efforts on behalf of this ordinance. With that, I vote aye, and the ordinance is adopted. Thank you. Next item, also a second reading, 474, please.
Amend contract with Squire Patton Boggs for federal representation for a one-year extension and increase amount by $198,000.
This is a second reading. We've had opportunity for a presentation, public testimony, as well as discussion. Any further business on this item? Seeing none, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance is, well, actually, let me thank some people here first. The Office of Government Relations, particularly Deputy Director Niels Tillstrom, for taking the time to walk us through this ordinance last week. This one-year extension will better align OGR's timeline on RFPs with the implementation of the city's charter transition to ensure smooth federal relations services come 2025. I vote aye, and the ordinance is adopted. Next item, 475, a second reading.
Authorize borrowings of not more than $38 million in anticipation of the Fire and Police Disability and Retirement Fund levy for FY 2023-24.
Second reading, any further discussion? Seeing none, please call the roll.
Ryan.
I'd like to thank our firefighters and police officers for continuing to serve our city. We are grateful. We appreciate you. I vote aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
I want to thank the city's debt manager, Matt Gurok, for walking us through the ordinance last week. The issuance of the short-term notes is obviously required to pay fire and police disability and retirement fund benefits early next fiscal year, while we await the collection of the property tax revenues that are not received until late November. This is necessary. I vote aye. The ordinance is adopted. Next item is 476, a second reading.
Authorize Portland Parks and Recreation to establish and collect fees in lieu of mitigation activities to implement restoration projects in natural areas.
Any further discussion on this item? Please call the roll.
Ryan.
Sorry. This change in authority makes good operational and financial sense. I'm really grateful. I vote aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance is adopted. Next item also a second reading. Item number 477.
Vacate a portion of Southwest Greenleaf Court east of Southwest Greenleaf Drive, subject to certain conditions and reservations.
Second reading. Any further discussion? Seeing none, please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance is adopted. 478, second reading.
Vacate a portion of North Kirby Avenue south of North Halleck Street, subject to certain conditions and reservations.
Any further discussion? Please call the roll.
Ryan.
Aye.
Gonzalez.
Aye.
Rubio.
Aye.
Wheeler.
Aye. The ordinance is adopted, and we are adjourned.